I'm Mark Gagan and you're listening to a special episode of The Voice of Insurance, produced in association with Beazley. Today's episode is going to dive deep into the fascinating world of Employment Practices Liability, or EPL. This $4 to $5 billion premium class of business is one that has grown into a standalone specialist line over the last 25 years, and is one whose growth is almost guaranteed to continue into the future. I say that growth is almost guaranteed because its progress is almost wholly aligned with the parallel progress of society at large. As society develops and standards and expectations are raised in the workplace, so the consequences of failing to keep up with best practice will become steadily more severe for employers who fall behind. Legislation changes and over time tends to create new forms of liability for employers. At the same time, unwritten societal norms evolve, almost always faster than the legislation can keep up. Behaviour that might have been acceptable or even encouraged 30 years ago may today be the cause of new grievances and complaints in the workplace. Similarly, as technological change accelerates and the way we work and where we work evolves, so new avenues for potential claims are being created at pace. Also, as workforces age and become more diverse, once again, the potential for conflicting views on what is and what is not acceptable conduct by colleagues, employees and bosses of differing ages and cultural backgrounds is increased. To sum up, some liabilities are statutory and laid out in black and white, but others are becoming far more subjective. One person's idea of absolute impartiality may be another's idea of unjustifiable discrimination. Something many see as harmless team-building fun might be harassment when viewed from another perspective. And because many employers and industry sectors follow very similar HR systems, employment practices claims are also potentially systemic in nature. This merely adds potential fuel to the fire. There's an awful lot going on here, and this is clearly not a line of business that the unprepared should be dabbling in. That's why I've assembled a trio of experts from underwriting, claims, and the legal profession to shed light from all angles on the core questions and key trends affecting this dynamic class. Bethany Greenwood is Beazley's Group Head of Specialty Risks, and Kamal Chibber is its claims-focused Group Lead for International Financial Lines. By the way, Kamal Chibber is known as Chibs by everyone, so this is how I'm going to address him from now on. These two senior insurance practitioners are going to be professionally assisted by Louise Bloomfield, a partner at UK law firm DAC Beechcroft. The intention is that this podcast will be of value to anyone with an interest in this burgeoning casualty line and the fast-evolving cultural and legal territory that it inhabits. I've spoken to the experts, so you absolutely don't have to be one yourself. Bethany is largely going to focus on the US market, while Chibs and Louise will be giving a view of the UK market. Time to get on with the episode. I started by asking Bethany Greenwood to set the scene and give us a primer on what the employment practices liability business entails.
As the insurance world goes, it's really kind of a new insurance product. So it probably started taking hold in the late 90s. Actually, when I started in insurance, EPL was kind of a new thing. And I remember it very distinctly as a new product we would talk to clients about. But it really started with the advent in the United States. Quite a few pieces of legislation were passed to protect workers. So the ADA Act, Family Medical Leave Act. So quite a few different types of legislation were passed that just was also a roadmap for potential litigation, employment litigation. And that was kind of the advent of this coverage. So relatively new as it goes with insurance.
What are the specific coverages? I suppose you're moving something everyone would have been familiar with, workers' compensation or employers' liability of different descriptions in different parts of the world. What is it about employment practices liability that created that need for a new product?
I mean, it really is, if you think about the title of it, it is the practices of hiring and working with employees. And when those practices either aren't necessarily followed, policies and procedures, or if there's allegations that they weren't followed. So the real crux of the coverage is wrongful termination, discrimination, and harassment. And so those are kind of the core major parts of the coverage. And then when you think about how the litigation environment has unfolded over the past 30, 40 years, there's a large portion of retaliation in there as well. So there could be a whole host of other types of situations that employees might face. And then if they're retaliated because of that, then that can also be a coverage under the EPL policy, which is a kind of a newer version of a covered wrongful act, if you will.
So I suppose if workers' compensation is what happened or it was something physical, this is way beyond that. Whereas before it was what you did, and now it's the way that you do it that really matters.
Yeah, and I think that's kind of a very good distinction because if you think about workers' comp, that's really focused on bodily injury or something like that happening. And when you think about employment practices, it's much more of either lost wages going forward or something that you've lost your job, you've been discriminated against and things, and not necessarily like bodily injury. And that is one of the core exclusions on an EPL policy is bodily injury. So we're thinking of all the other pieces that go into the relationship between an employer and an employee.
Any other main exclusions? Obviously, yes, it's the bodily injury out because that should be covered by workers' comp and other forms of employers' liability around the world.
Yeah, so bodily injury, and I think there used another exclusion. I used to always call it the alphabet exclusion. So it literally lists out multiple types of legislation in the United States. And the idea there is that we're looking for companies to comply with those. We're not looking to be the backstop for companies to no longer abide by different types of legislations. And then there's also an exclusion prior noticed claims, and that becomes a little bit more important in employment practices than it might in other coverages because these claims can start in a very nascent way as what we would call an EEOC complaint, Equal Employment Opportunity Commission complaint, but then it could turn into, in many years later, a class action with multiple parties to it. So that prior notice claim language and exclusion is important for both sides, either buyers of insurance or providers of insurance, because you want to understand what the ramifications are. And that does change the landscape a little bit than maybe some other financial lines insurance.
How does that work exactly? So what are you excluding specifically there?
Well, basically, if you know of an instance, so if you've had a complaint alleging a certain situation, and that is deemed as a claim under the policy, which an EEOC notice most likely is, then that triggers the coverage that's in place at that time. And then in 3 years later, if that manifests into a different type of claim and you're with a different insurance company and you purchase different limits at different price and retention, what's going to be triggering or what's going to be responding when you notice the EEOC complaint or when you're noticing that, let's say, it manifests into a class action. So it's very important to get the language right and the notice provisions right and making sure you're following the T's and the I's of the contract.
Just in case you didn't notice, we'll be using EEOC as an abbreviation of the Equal Employment Opportunity Commission from now on. So EPL is all about what happens in the workplace that isn't related to bodily injury. And claims reporting requirements are key, as this is written on a claims-made basis. We often think of the characteristics of insurance classes by the relative frequency and severity of their claims. This is what Bethany had to say on the subject as it relates to EPL.
When you think about EPL coverage, where you get to a severity situation typically is that you have a high wage earner alleging discrimination, wrongful termination, retaliation, or you have multiple individuals alleging the same facts and circumstances, and then that turns in oftentimes to a class action. So when you think about EPL, you often think about higher frequency than, let's just say, D&O, but typically we would think of it as a lower severity. But I would say with the advent of those two situations I just described and the overall social inflation impact, we're seeing not only higher frequency, but also higher severity in EPL as well.
So the answer is both. Frequency is to be expected, given that claimants are most often individuals. But of course, if those individual employees earn a lot or come together in a class action, severity is the likely result. Next, I asked Bethany what sort of insured typically buys the cover.
It really depends. And I think the size of the organization usually dictates how you purchase it. So if you think of your smaller organizations, SME, maybe they would be buying a package policy with the other types of GL coverages. But for the mid-sized companies, if they're buying a package policy, it would be with the financial lines. So it would be with the D&O, the fiduciary liability, the EPL, and then the crime. And you package that up together and kind of that's your management of your financial lines policy. The larger an organization gets, the more often they're going to buy standalone coverage for all of those different financial lines. And so you'll see employment practices being purchased standalone with multiple layers, similar as you would to D&O when you get a larger organization. So it really is the size and how many employees and what kind of coverage they're looking for that dictates how they purchase it.
GL is, of course, general liability. Really, anyone who is an employer has exposure here, and so employers of all sizes buy the coverage. So what's the market like at the moment? How are supply and demand stacking up? We know that adjacent lines have been on something of a ratings rollercoaster over the last 5 years, while other casualty lines have continued to harden. How has EPL fared?
I would describe the market as soft and pretty inconsistent. So we had a lot of severity and a lot of frequency when you look back at some of the social movements, Black Lives Matter, #MeToo. There was a lot going on. A fair amount of carriers were seeing the losses and pulling back a little bit on coverage and capacity being deployed. Then we went into COVID, and there was a lot of concern with people handling what was happening with vaccine mandates or work from home. So there was some uncertainty there. So people were still being a little bit conservative, insurance companies. And then we've had what I'd call maybe a little bit of a COVID quiet or a litigation kind of pause, because people weren't going into the office and courtrooms weren't open and people weren't filing complaints. So I think that COVID pause saw people feel a little more comfortable about the performance of the product. And that, coupled with the fact that the public D&O market has softened quite a bit, we've seen quite a bit of supply come into the marketplace, and carriers, legacy carriers, new carriers, whether it's trying to make up for the loss in the public D&O premium, whether it's feeling confident because we had this COVID pause, but we are seeing demand either stable or decreasing and supply increasing, which is, economics 101 causes a bit of a softer market. When you think about how insurance companies are put together, oftentimes these products are written in the same division. And so if your budget is $100 million and you're not making it up on the D&O, people are going to start to divert into EPL, which is surprising because while we did have the COVID pause, those numbers have come back in a vengeance because you have all of the stayed litigation that might not have been moving very fast coming back to life. You have a lot of new situations that are arising, that are being claims that are made with different types of allegations, and the world will continue to change, and I won't be able to tell you what we're going to be thinking about in 5 years' time when it comes to EPL litigation. But when I look at, we have AI litigation, different types of things that we didn't think about 5-10 years ago. So I don't think the environment is actually showcasing that it should be a soft market. It feels like something that we should be focusing on, and we are at Beazley focusing on that.
So stable demand and strong supply, perhaps because of slightly less attractive conditions in adjacent lines, such as D&O, mean that this is currently a good market for buyers. Now that Bethany has set the scene, it's time to get into this product in more detail. Bethany described the core claim as any form of wrongful termination, which over in the UK is usually phrased as wrongful dismissal. I asked Chibs to describe the core claim in this line.
I think the most typical claim is unfair dismissal. That's the most common claim that we see in the tribunal. Why is that? I think there's an increased awareness of employee rights.
It's more, not that there's more unfairness, it just means that people are better at bringing unfairness claims, that they understand legally how they're likely to succeed in bringing an unfairness claim. Is that right?
Yeah, they're just more aware of their rights, quite simply. And I think there are more employee-friendly rights. That's not to say there weren't in the past, but I just think they're aware of their rights. There's more education around this. And I think it's good, it's protecting the employee. It's making sure that they're working in an environment that they're comfortable in as well. I think that's important. So, yeah, they're the typical claims and why we're seeing an increase in those claims.
By the way, the tribunal Chibs refers to is an employment tribunal, which is the UK's standard lower court for dealing with employment disputes. So it seems that wrongful or unfair dismissal or termination claims rule the roost on either side of the Atlantic. But why is this so? It's time to bring in an experienced employment lawyer. Over to Louise Bloomfield.
It's an interesting one because obviously employers are able to dismiss people, and it's really the unfairness comes from if they do it badly. That tends to be the nub of the issue. So from a UK perspective, and I obviously practice employment law in the UK jurisdictions, in the UK we're quite procedurally driven. So there is a basic process that you need to follow to ensure that the dismissal is going to be fair, particularly around performance and capability, where you've got to give people a chance to get better. And that's the whole point of actually a capability process. It isn't about punishing people. Really, it should be from the space of we want you to improve. But clearly some dismissals need to be pretty fast. This person has stolen from us, or this person has been violent, or this person has caused us a significant loss and we need to remove them quickly from the business. And really the way in which things become unfair is if employers go about it thinking more about the money rather than the actual risk. And actually I think that can be problematic when they misstep in the process to get to the end result. When I say the money versus the risk, really what I mean there is obviously what the employer's bothered about is getting their product out, or is there a reputational risk, or what problem is this person causing us actually when it comes down to their P&L. But if you go about it in the wrong way and dismiss that person, they then bring a claim, and actually allied to that unfair dismissal claim is, well, I think you've only dismissed me because of a protected characteristic. And a protected characteristic can be their sex, their race, their age, their sexual orientation, their disability, whatever. And actually that's got something to it. And the employer's not really thought about it, or has deliberately thought about it and thought, we don't care about that because what we're really bothered about is the bottom line for us. Actually, that can manifest itself in quite a significant risk, because certain tribunal claims, if a person can show that as a result of that dismissal, they've suffered a loss and that loss is going to go on for a significant period of time, and they're a high earner, that could be hundreds of thousands, if not millions of pounds worth of damages being awarded by an employment tribunal. So actually, driver starts off with the bottom line for the employer, but actually ends up costing them more in the long run.
When we talk about dismissal, presumably this is sort of a two-way thing. You are dismissed, you're fired. We know that side of it. But are there more these constructive dismissals, effectively dismissing themselves, say, I can't work here anymore, so it will be deemed as a dismissal?
Yeah, the vast majority of claims that we see are unfair dismissal claims. They can be a mixture of the two. They can be dismissals by the employer, but also within that banner of unfair dismissal is also constructive dismissal, where the employee, like you say, Mark, says, this place is so intolerable, or the way you've treated me is so bad that I am effectively resigning with immediate effect because your conduct as the employer is so bad that you effectively breached my contract, and I'm therefore resigning. So we do see quite a lot of that as well. More so in situations where the person's working under a lot of pressure, depends what sector they're in, if they're in a particularly significant role, and actually there's more expected of them, we can see them actually saying, it's got too much, I'm going, and then they can bring that claim as well.
Now that we know a little more about a typical claim, how long does that claim take to settle? Back to Chibs.
If you put me on the spot, which you are, asking me right now how long does it take, I'd say anywhere between 6 months, 2 years. But when the claims do start gaining momentum, 2.5 years is not uncommon, truth be told.
So we're talking about a reasonably short to medium tail class of business here, depending, of course, how quickly courts and employment tribunals can hear the case if it gets that far. Claims really come to a head after the employment has ended, but let's get into more detail of the drivers. One factor driving claims of late has been the post-pandemic standoff between employers and employees over whether working from home can continue as it did during the pandemic, or whether a return to the office is warranted. I asked Bethany if the archetypal aggressive CEO's call for mandated mass returns to the office might be storing up trouble.
I think we're going to continue to see this. And I think, again, it's how you handle it, right? Do you give people the option? Let's say you move far away. You can move closer to the office and come in 2 days a week, or you can be a home worker, or you can no longer work here. So sometimes it's not the end result. It's the process that these companies take to get there. But it also, if you reverse course too, were you hired during the pandemic, and were you hired with flexibility and now that's changed? Or are you being retaliated and not getting a promotion because you've chosen not to come in the office? So it's extremely nuanced. It's not necessarily that each person could have a legal case to say, you're telling me to come in 5 days a week and I don't want to, so I have this legislation I can sue you against. It's a little more nuanced to that. So how was I hired? What were the options given when you made this change? Did I not get a promotion, or am I treated differently because I'm not coming in? And so I think we're going to continue to see that unravel. And if you look at, so many companies are doing things very differently, where people are still allowing lots of flexibility, or you have other large tech companies that are saying you need to come in. We're going to see that unfold quite a bit over time.
Fascinating. Once again, it's not always exactly what you do. It's often the exact way that you do it that really matters. More on this from Chibs.
I think there's been a lot of noise around working conditions, be that hybrid working conditions, remote working conditions. People feeling, well, actually, they've become now used to a new way of working. And then when returning to work, they're maybe not seeing, well, in their eyes, those changes adopted by their employer. And as a result, they feel like they're being discriminated against. Well, actually, I'm a working parent. I need to be at home. I can do my job here. I don't need to be in the office Monday to Friday, 9 to 5. So I think that has had an impact on the claims that we're seeing, certainly.
So work from home is going to be a factor and may give rise to accusations of discrimination. There's a lot more on this in a fascinating exchange with Louise.
The real challenge there is during COVID, where obviously everybody had to work from home unless, you're in sort of special category, productivity was really high. But then the number one reason why employers are saying, we want you back in the office is, we don't think you're as productive. But it runs completely counter to what was happening during the pandemic. So it's a really hard message to sell. I mean, a lot of it, to be honest with you, I think is driven by empty office space and costs as well. But I think there's also a cultural point in there. Remote working has its wins, but it also has its downfalls as well in terms of collegiality, people getting to know people, lone working, mental health issues. So there is definitely something to it. But that mandating people back full time has real risk. One, because if people have been working in a remote or hybrid way for a number of years, that is effectively their contractual entitlement now. That's effectively custom and practice. So what we're asking them to do is change their employment contract to come back to the office. And unless there's real flexibility already within their employment contract to insist upon that, an employer is going to have to go through a fairly seismic consultation process. Yeah. And if employees refuse, we start to get into the realms of dismissing them, really into sort of fire and rehire territory as well. That's the practical risk of how do you do it? But I think also what we shouldn't overlook is the discriminatory risk as well. So a lot of people, one, obviously like working from home, but a lot of people need to have that ability to work from home for caring responsibilities. So childcare, it could be caring for elderly parents or other family members, where that flexibility gives you that. Suddenly, if that's taken away from you, it has an indirect discriminatory impact on those people. There's also disability as well. Reasonable adjustments. People can work from home or in a remote way. It actually suits them from a physical disability perspective, but also a mental health perspective as well. Particularly if we're asking people to, the return to the office requires significant travel and that causes significant anxiety. Employers have a duty to make reasonable adjustments, and they have to make sure that they factor that into their thinking about trying to get people back into the office.
I think over my time interviewing lots of executives about work from home, one of the only things that they would say, one of the disadvantages, of course, from working from home, it's harder for a junior member of staff, a less experienced member of staff, to really pick up, to learn from more senior, more successful members of staff, to learn how to do it, how to do the job, all the bits that you can't write down in a manual, the behaviours and ways of doing things. Yeah. Again, I presume that's very unlikely to have someone say, well, I've been passed over for promotion because I don't come to the office enough. It's going to be down to performance, ultimately.
It's going to be down to performance. And if an employer can tangibly show that the reasons why you aren't where we expect you to be is because you're not in the office enough, because you're not learning, then that becomes quite a compelling reason to mandate that person to come to the office.
Because you need to learn.
Because you need to learn. And this is the way we work.
Work from home looks like it's a subject that's going to run and run. Louise also started focusing on practical loss mitigation strategies there. There'll be much more of that later on. Before we move on, we need to examine some of the other new possible claims drivers that might be of concern. I asked Bethany to give us a broad overview of what underwriters are focusing on.
We always look at what the EEOC is focusing on. Their focus is discrimination in recruitment and hiring practices, protecting vulnerable workers, and that goes very far. The use of AI. So we think about that in two different ways. One, our recent study showed you've got a lot of companies investing in AI. And so there have been allegations that AI screening for potential recruitment can have discrimination bias built into it. So there's that. But then you also have the advent of potentially AI replacing workers and having reductions in force. So the AI legislation that will be potentially coming down, we're looking at that. Those are areas that we're always focusing on and thinking of what the next thing, when you look at pay equality, and there's a lot of transparency in pay conversations going on. So we're looking into that. So I think trying to be ahead of the curve is important, and reasonable accommodations for employees, not just physical, but also neurodiversity. So there's a whole host of things. But I'd say if you look at, like, if I had to give a couple of themes, it really would be discrimination around recruitment and hiring practices, which could include AI, protecting vulnerable workers, which could include neurodiversity or any type of vulnerabilities, and reasonable accommodations that go in with that. And then the third, I would say, is probably reverse discrimination. So we've seen, obviously, a lot of discrimination cases over the course of my career and the advent of this product. And now we're seeing these reverse discrimination. So age discrimination, different types of things where somebody isn't getting the promotion because of their age. And so we're seeing some different types of claims manifesting from that.
So reverse, not in the sense of positive, as sometimes described as positive discrimination, but things like ageism, that sort of thing.
Right. Or if a gender discrimination, but brought from a male where you might originally think it'd be brought from a female.
There's a lot of interesting forces at play here. As the world becomes more aware of discrimination, groups who might in the past have been more likely to have been accused of doing the discriminating are able to turn the tables and become the plaintiff. Bethany mentioned AI, artificial intelligence, there. Let's open this theme up. Where else might AI be a cause for concern? I had a long conversation with Louise about this.
We're seeing a lot more use of AI, obviously, within businesses too. So how ready are employers to embrace that new technology to manage risk as well within the employment space? Because we're seeing AI is going to be a significant factor in the world of employment. Reading a McKinsey report that talks about, frighteningly, by 2030, which is not a million miles away, saying something like 30% of working hours will probably end up being AI driven, which is high. So how are we making sure that employers are thinking about that in terms of upskilling their staff to be able to use that technology? Are we displacing people by the use of that technology? So are we looking at redundancies or reskilling of employees? What type of employee do we want to recruit as well? Is it people who are more technologically savvy? The fact that more older people are staying in work longer. I'm not wishing to stereotype, and I'm not, but actually therein lies a sort of dichotomy between older workers who haven't had the benefit of the education that our younger workers have had, where it's very much more technologically driven. How do we make sure that we're not missing out on people who can adapt to that technology, and also not creating an age discrimination risk by effectively writing them off and saying, you can't do this, it's a young man's game. Yeah. So there's all sorts of risks that kind of sit with that technological advancement. And I think a lot of employers are getting there, but I think for me, over the next 5-10 years, it's going to become much more part and parcel of what we need to think about.
It's funny because this is the great paradox. Of course, the whole point of AI is that you don't need to know the tech anymore. You just need to know how to ask questions.
Yeah, absolutely.
So anyone can do that.
And also what questions are being asked into it as well, because that's one thing that I've seen businesses wrestling with is, do we even use this? Because what's going into the AI to create the work could be very sensitive. And then it's work products out there and ChatGPT or whatever. Where is the sort of human element in that? And fundamentally, do we need that human element? And I think that's really, really important. What's interesting, actually, though, I did have a query from a client the other day, actually, about AI. And it turns out that an employee of theirs has been passing off work, was hired for a particular job, and has effectively been doing his job using entirely with AI, which was never permitted by them. But in this weird moment of actually...
But the performance was good.
The performance was seemingly good by the AI, but not by the individual, and that's not what they're hired for. So how do you manage that?
Yeah. And I suppose there's those biases. If you're using AI for your recruitment, you need to be really careful, one presumes, because you just don't know what inherent biases might be built into the algorithm.
Absolutely, yeah. And then obviously we've got job applicants can bring claims. You're baking the AI into your recruitment process and it has that inherent bias and sort of spits someone out for a particular characteristic. Then that is deemed to be a decision of the employer. We can't blame AI for that. So the employer has to own that risk.
Yeah. And again, it's interesting because that's a systemic risk. Again, it could be watching daytime TV and having an advert from a claimant law firm saying, "Did you ever apply for a job at British Telecom?" And you say, "Oh, I did actually. I didn't get it."
Yeah.
Well, you may be entitled
You may be
compensation.
able to bring a claim. Absolutely.
Yes. And what about? And we haven't really seen anything about AI making people redundant and then them bringing claims. That's probably too soon for that, aren't we?
I think we are too soon. We've always seen redundancy claims where a business has introduced a new way of working, a new bit of kit, a new bit of software, and then them saying effectively been displaced by that. But I think it will become much more acute. You know, if we believe the kind of McKinsey view of the world that we're looking at arguably a third of working hours becoming automated, that risk of more redundancies and more restructures is only going to become more acute as well.
Yes. We just hope it makes us all far more productive and all better paid. We've even had lawyers being mentioned for the first time, all the professional classes and journalists too, by the way.
It isn't just about automating factories. That's what everyone kind of conjures up in their head, don't they? This is about robots building things, but it's not. Actually, it is more about that white collar working as well, the way in which we do things, the sort
It's language based.
Exactly. So
And we're both in language based professions.
Quite, yeah. So it's not Rise of the Terminator, it's Rise of the computers, isn't it, to do the job that you're doing when you're typing away. I do hold on to the kind of crumb of comfort that I know it learns, it's an artificial intelligence, but I still think, particularly in employment law, that human element, that personal relationship, they're all still really important for employers. It's not as though you can run a whole law firm just using AI. I still think, for instance, you've got to be able to build those relationships.
I really enjoyed that. It's really interesting to see how very new, cutting-edge technology can cause new problems in an area that is already relatively mature, such as age-based discrimination. AI is something that only existed in the theoretical and scientific realm until a couple of years ago. It's only when it becomes adopted that problems will start to surface. Societal change really is a massive factor. More from Louise on this topic. I asked her to detail types of claim that are currently less common, but are becoming more so.
We are seeing quite a few claims for whistleblowing. I think a lot of that is driven by, societal position of people speaking up, being more open to call out things that employers are doing that they consider to be wrong.
Is that because they were dismissed?
Normally it will be that they've been dismissed and then they will try and say, well, I've only been dismissed because I have raised these concerns. And then part of our job is to say, well, is that true or not? But I think culturally, we're in the age now, in a post-Me Too digital age, where people feel empowered to speak up more. We are seeing more claims around that speak up culture. I'm not happy with this. I'm raising it. And then employers have got to face the consequences if they choose to dismiss or, in the employee's eyes, treat them less favourably.
It seems that society moves quicker. Well, I suppose it's natural that society would move quicker than legislation, which catches up with society. Then litigation follows after, and case law follows after the laws changed. So it's probably 20 years after everyone changed their opinion about what is acceptable and what is not. So again, so it sounds like it's the people are deciding already what's acceptable and what's not. And then employers have got to always, presumably an employer, doesn't matter what the law says, you have to be really, really cognizant of what your employees are thinking of.
Absolutely. We can just see from the media, we see it all the time. We see what is acceptable. Things that were okay in the past are no longer okay.
Yeah.
And we're seeing that played out in terms of sexual harassment is a particular one. We only have to see the UK news at the minute of celebrities and how they've behaved in the past now coming to the fore and saying that's not acceptable anymore. But we're seeing that in the workplace. So we'll see, for instance, employees who are now saying 15 years ago, this is what was said to me. And we're getting a lot of claims where it's historic behaviour because people feel empowered to speak up and call it out, but they're judging it by today's norms rather than what was the norm at the time. And they're hard claims to defend, not least because of the passage of time and the fading of memories. But also, how do you judge that? Because what one person feels is acceptable, another person can feel is unacceptable. And that is a challenge for employers. It really is.
I don't envy Louise for a moment. So, historical claims and whistleblowing look set to be a source of anxiety well into the future. Time for a little light relief. When I get a senior claims executive in front of a microphone, I always ask them, what's the strangest claim that they've handled in their careers? Here's what Chibs had to say.
I did do some research on this because I've been handling EPL claims for a number of years, and I was talking to a colleague of mine, and she trumped me, I must say, when it came to strangest claim. She had an insured who asked one of their employees to take a routine drugs test. The employee refused to do this, saying, well, it would light up like a Christmas tree. And the insured proceeded, well, that wasn't good enough for the insured, and said individual was then dismissed for gross misconduct. But because the company hadn't followed the ACAS code of conduct, the employee then brought a claim against the company, and it was settled by way of a settlement agreement before it really entered into the tribunal process. But I think that certainly was one of the strangest claims.
I hope they weren't a bus driver or train driver or something. But
well, yeah, quite. Yeah, exactly.
By the way, ACAS is the UK arbitration service for resolving employment disputes. So now we have seen the array of possible problems facing us, any remaining waivers will be fully aware of the need to be properly insured. But how should employers be protecting themselves against this seemingly inexorable wave of exposures? What's best practice? Let's get back to Louise.
The things that really help us is an employer who has followed our process. There are basic processes out there that employers, even if they don't have a process today, ACAS, which is the Advisory, Conciliation and Arbitration Service, which is a free service, provides guides for employers on how to do a good dismissal, how to handle a grievance, how to handle a disciplinary, how to handle sickness absence. And it gives them the basic tools to do that. So what we're looking for is, have they met those basic processes? Because a tribunal is entitled to take into account that ACAS guide as being the baseline for employers to do a good job. And if they haven't, they can actually increase compensation in dismissals by up to 25% if the employer hasn't even followed those basic processes. So our first step is to look at it and go, right, have we got a process? Because if we haven't got a process, particularly say in a dismissal case, then we're already on the back foot. If we have got a process, we've at least got the startings of a good defence here. How good is that process? And along the way, are there any missteps as well? So they're all important. In the discrimination space, I think what we're also looking for is training. Has an employer given its staff, and its managers in particular, good training on how to handle things like sickness, disability, people's particular issues where they may need adjustments within the workplace? Because if that training's in place, then we can show that the employer has been responsible and has shown its staff the way in which to handle things properly. And that's always a good start, because actually in discrimination claims, an employer is vicariously liable for the actions of its employees, but it has a line of defence that if it's effectively trained and put reasonable steps in place to stop the discriminatory act from happening in the first place by way of its culture, training, ethos, policies, handbooks, all that kind of stuff, then actually it can push that liability away from the employer onto the employee that's committed the act of discrimination. So we're looking for all those things as well. And having those kind of steps in place will show us this is an employer who cares, who knows the right way to do things, and that gives us good arguments to say we're in a good spot to helpfully defend this case.
So, good procedures and practices that can be demonstrated and proven are the beginnings of a good defence. Here's more from Chibs.
Employers need to be as up to date and getting ahead of new regulations as quick as they can to adapt to this new working lifestyle that employees are becoming accustomed to. They might not have the experts in-house. They need to go to third-party providers, go to legal advisors, find out what regulations are in place. Are we compliant? If we're not compliant, we need to be compliant, because otherwise we could find ourselves on the hook for a number of potential claims. And if they don't then have the, not to plug here, but if they didn't have the right insurance in place, then that's coming out of the company, and that could have a detrimental effect on the company. So they need to be reviewing their policies and procedures. And if they find themselves on the wrong side of any claim, they're likely to present a stronger defence if they actually can demonstrate they have these policies in place and they're doing their best and adhering to such policies, doing the right thing by their stakeholders, but also their employees, their staff, the people who are there day in, day out.
So good culture, along with evidence that it is real and not just a set of employee manuals gathering dust, can be a strong defence. Here are some more really interesting details from Louise.
An employer can have a defence if it can show that it's taken all reasonable steps to prevent the discrimination from happening. The more we can have as lawyers to show that, including things like common statements from CEOs, weekly huddles with staff, all the different ways in which these policies are communicated, literally tangible things like posters, all sorts of things. You can even start to embed these things into people's performance reviews as well. So things like making sure that as a manager that you're tackling behaviours. If there has been a particular issue within an organisation around grievances, are they able to set KPIs to show we want to reduce the number of grievances? All these things help to embed it. But it also, from a claims perspective, if we can show that the employer is taking it seriously, is doing something about it, is being proactive, hugely helps from a defence perspective as well.
More sage advice there. Now, to bring this back to an underwriter, how does an underwriter go about rating this risk? Presumably, evidence of adherence to best employment practice should be a given. What do Bethany and her underwriters really most need to become comfortable with an insured?
Loss history is huge. It's funny. Sometimes people think we have never had a claim, and so we're a really good risk. In actuality, what we would like to see is that we know you're going to have claims because people with employees are going to have claims, but it's making sure they're not systemic in one geography or one allegation. It's that you know how to handle them and that you handle them correctly. And so loss history for multiple reasons is very important to see what's happening and what the patterns are. Number of employees is large, obviously, because that really gets the tranche of who could be suing you, what your potential litigants are. Geography is extremely important. I know we are the United States of America, but each state has very different laws, and many are very pro-employee, many are pro-business, and really understanding what states that those employees sit in is extremely important. What's the tone at the top? What's the policies and procedures? How up to date are they? How sophisticated are they? What's the litigation history and the team that would be handling that? The financial wherewithal of the company. Obviously, litigation increases when there's reductions in force or different types of transactions that go on. So it really is a very holistic underwriting approach. And when we're lucky enough to sit down with clients, typically that does happen when they're larger clients. That's hugely important because that tone at the top really can come through because you're understanding how important they take this with the policies and procedures that they put in place.
So the key is to look at everything about the company, procedures, but also its financial state, and the culture coming down from senior leadership can all have a big effect. And of course, the loss record can tell an underwriter an awful lot, especially if it is showing that a firm might have a particular cultural blind spot that is causing certain types of claim to occur more regularly. Companies doing badly financially are an obvious source of grievances. But Bethany also told me that fast-growing firms can be equally problematic if their HR and legal functions aren't keeping up with the size of the firm. Another topic that I wanted to get into was how close the relationship has to be with the insured. This is a class of business that is adversarial and sometimes painful. So I imagined that getting to know customers and really winning their trust would be even more important here than in other classes. Here's an exchange on the subject with Bethany.
Trust is difficult. It's difficult to give an insurer your trust because you're effectively admitting at some point you may have to say, you know what, we could have done this better. We could have handled this better. And at that point, they're kind of putting themselves in your hands a little bit to say, well, I hope you're not suddenly going to reject the claim because I could have done it better.
That honesty. And again, that comes back to us understanding this happens. We've seen this before. These allegations are something that is potentially could happen, even if you do the best you can. And that's why the underwriting really looks at the tone at the top, all of the policies and procedures, all the affirmative defense that you can have. We want you to take all of this seriously, do everything you can. But even when you do all of that, these are humans and things happen and people either make mistakes or it doesn't matter what happens. You can always have an allegation and be sued. So those are the times that we're really there to partner and help back up our insureds. And to us, that's extremely important, that relationship.
So it sounds like is the sort of class of business where if you can really build that relationship and keep renewing and building more and more trust between you, it's just going to get better and better, particularly when they see the first proof of the pudding is with the first few claims coming through and then seeing that you're doing what you said you were going to do, and you can start to build more trust and they can share more information with you, or they feel much more comfortable sharing everything with you.
Exactly. And as I said before, sometimes these are extremely personal, right? You're making personal allegations about somebody that you may be dealing with. And so for us to be able to hold someone's hand to get to the best outcome for all parties involved, that really does build a lot of trust on both sides. And so where in property, the building either burned down or it didn't, these are human allegations about human behaviors, and it really does become a lot more personal.
A huge amount of empathy would appear to be the most important qualification for any claims professional operating in this space. You win trust by accepting that bad things happen, even to the best run, most enlightened and caring employer. Once again, it seems the insurers who are going to do best in this class are the ones who are able to win a reputation for being a genuinely trusted third party who isn't going to use any of your disclosures against you. High service levels and the ability to stand by a client at a time of extreme stress are also going to be key. We're coming to the end of this tour of everything EPL. I certainly feel that knowing what I know now, it's not a product I would like to be without. But let's let Bethany have the final word. I think this sums up how EPL is developing into a core product for the foreseeable future.
When we talked about the advent of this EPL coverage, originally the HR directors were very against this coverage, at least anecdotally in my experience, because they felt like this is our job. We are here to protect the companies. And over the last 34 years, they've actually come to understand, embrace, and really partner with us on the coverage and really feel like it's a tandem approach.
So this is a product that has gone from being something the HR department was initially sceptical about to something that they wouldn't dream of living without today. I think that's all you need to know. Going back to what I said at the beginning, this is clearly a line of business that is going to keep growing. It will grow in the most sophisticated and saturated markets as society and new exposures continue to evolve, and it will grow in emerging economies as living standards rise and employee protection legislation comes online. If this has sparked your interest, Beazley has just launched a report entitled Spotlight on Boardroom Risk 2024, which deals with the evolving boardroom risk landscape from business interruption and supply chain risks to regulations, reputation and employer risks. I highly recommend this as further reading. There'll be a link to the report in the notes. Thanks so much to Bethany, Chibs and Louise, and to you for listening. Well, I hope you enjoyed today's episode. If you did, don't forget to subscribe or leave a like or a review or recommendation on whatever podcast platform you used to access this programme. These really help get the word out. Before we go, just a quick reminder that advertising slots are available here and in other places in the Voice of Insurance podcasts. Podcasting is the fastest growing medium and attracts a high quality audience of key decision makers. It's also an intimate medium where you, the listener, are right in the room with me and the interview subjects. Needless to say, that means it's a great way of getting your message out directly to an audience because you know you've got their full attention. It's also very cost effective. So get in touch with Mark at thevoiceofinsurance.com to find out how you could be speaking directly to the industry. Voice of Insurance is produced by me, Mark Gagan. Music was written by Anna Gagan and produced by Carlos Gagan. Check out more podcasts and written comment pieces at www.thevoiceofinsurance.com.